Did you know that your court action does not necessarily have to be adversarial, or at least ramped up adversarial? Most cases in the Georgia courts must go through the mediation process before the parties get in front of a judge to argue their cases. Joy Edwards with the Edwards Law Group. Let's talk about the mediation process for your case. Whether you filed for divorce, a modification of custody, child support, visitation, whatever the court action is, most judges mandate or require you to go through the mediation process before you go in front of the judge and spill all your dirty laundry. Some people actually want their lives to be like a reality show that we all have seen where people behave badly in the courtroom. But for most of you, any court action is a painful court action. It's scary. It's terrifying. Like you've got all of these emotions going on. And having the opportunity to step back from like the high level of it all and just be able to be yourself, to be human, to express what you want, what your needs are, without the pressure of anyone but you and the other side making a decision is invaluable. That's what the mediation process affords you. Now, just because you're not arguing your case in front of a judge doesn't mean that mediation cannot get you to the outcome that you want. It just gets you there in a different way. It gets you there without the pressure of having to argue your case and having someone else believe you. You will still have the benefit of an attorney who's going to prepare your case for mediation if you hire an attorney. If you don't and you decide to go it alone, you're going to have that stress. You're going to have to prepare your case. You're going to have not only all your arguments together, but all of your documents together. So if you're arguing about child support, you're going to have all your figures. If you're arguing about a modification of custody, you're going to have all of your situations. But at the end of the day, you can still get the outcome that you want if you are prepared properly. Mediation can be just as rewarding and just as taxing as an actual trial. The key to a successful mediation is being prepared and keeping your end goal in mind. Why are those things important? They're important because if you know where you want to go during the mediation process, you keep that in mind. And having a roadmap of how to get there is also important, and that means being prepared. At the Edwards Law Group, your attorney team is going to prepare for mediation in the same way that they would prepare for trial. And how is that done? With the goal in mind to get you your best outcome. Have you been handling your legal action on your own without an attorney, or with an attorney that you're not comfortable with or confident in, and now your case has been scheduled for mediation? It's not too late. You still have the ability to take control over the situation and talk to us. You can come in, we can talk about where your situation is thus far and where you want to go so that we can help you get there. Give us a call, book some time with us, and let's get you to and through the mediation process so you can get to your successful outcome on the other end.